FDCPA is an acronym for Fair Debt Collection Practices Act. It's essentially a series of laws that protect consumers against debt collectors. For instance, if you're getting a debt collection call 5 times a day, most of the time it's actually in violation of FDCPA. If the debt collector is harassing you or threatening you, that's usually a violation of the FDCPA. So it's a series of laws that protect consumers in debt collection practices. You start by wanting to talk to a lawyer and then explaining your situation. You're going to want to explain the dates that they called, the persons that they spoke with, what they said, and in as much specificity as possible, because the key for us is if we're going to file a demand or send out a demand or file a complaint, then we need to make sure that our facts are right, and that comes from the person that calls us. We want as much detail as you can possibly give us in order for us to be able to put down on paper what the specific violations are. For FDCPA, the only time there would be documents involved is if they're getting letters, collection letters. Then we want the collection letters and the mail envelope that they actually come in, so that we can evaluate the letter, see if the wording in the letter is accurate and whether or not there's anything in the letter that is a violation of FDCPA. Other than that, there's really no documents for phone calls. It's more of, we ask you to fill out a call sheet log, which tells us when the calls came in, what did they say, who said it, and it just kind of gives us a little bit of a timeline. It's important not to dodge the calls, because the reality is, in order for us to make a case, we need to know who's calling. We need to know what they're saying on those calls. That's really the key. So, for example, you owe somebody $500 and they're calling you and trying to collect. Well, they're allowed to call you and try to collect. You owe them $500. What they're not allowed to do is call your mother and tell your mother that you are in debt. Call your employer and tell your employer that you are in debt and say that you're going to go to jail if you don't pay this. They can't call you 10 times a day regarding that debt. So it's really important to take the call, to know who's calling so that you can identify the caller, because sometimes they just call from different numbers and it's the same creditor. So we don't want you to dodge the calls, but we definitely want you to log them and keep track of them, because all of those things add up to violations of law that we would later show a judge or a jury and show that they are violating the law. The next thing is that I would verify all the phone numbers, run them through Google, run them through other lawyers who take cases against particular creditors, verify the phone numbers are for those creditors. I would look to see exactly what language they're being used with, and then I would determine whether or not it's a demand letter or a complaint. And the difference really is just the amount of damages. So most of the time you can, for FDCPA violations, collect statutorily $1,000. That's what you would get if there's no other damages. So if all it is they're calling you and they're violating a law, or they sent you a letter and it violates the law, it's a statutory violation, so you get $1,000 plus attorney fees, however much we rack up in getting you that $1,000. There are ways to get more than $1,000, but you have to have actual damages. So, for instance, if the creditor calls your brother, your mother, your father, your sister, and tells all of them that you're going to go to jail if you don't pay this amount, or if you don't return a car that you needed to return, or if you don't give them a call back because you need to give them a call back, and they start to threaten jail time and they interfere with your employment by calling your employer. Now we're talking a little bit of actual damages in terms of emotional distress, because all of those factors add up to how are you reacting to something like that. So if you're unable to sleep all night for 5 months because of these nonstop phone calls, and if you have to go and seek a therapist because of these nonstop phone calls and what we really call is harassment and threats, they can qualify into actual damage amounts that result in essentially emotional distress damages. And as a result, you can collect more than that $1,000 statutory if you fall into that category. But the more facts you have, the better opportunity we have to determine what your damages are. So typically, and in recent times, we're getting a lot of calls regarding car dealerships and wrongful repossession. Here's what happens. Car dealership sells you a car and tells you you're good to go. You drive off the lot. In reality, the car dealership has 10 days to finance the vehicle. And if they can't finance it within those 10 days, they only within those 10 days can notify you and tell you you have to bring it back the car. A lot of times what's happening is the car dealership waits 30 days or 45 days and then tells you, oh, we can't find financing and you need to bring back the car. And at that point, they're no longer legally allowed to do that. So if the dealership can't find you financing, the dealership becomes your finance company after those initial 10 days. And you start making payments to the dealership. We have scenarios where the dealership starts to call you, your family, your coworkers, telling them that you need to return the car, that you have stolen the car, that they're going to file a police report against you, and that you will go to jail. All of that is an FDCPA violation. They cannot cancel a contract after those 10 days. And those phone calls cause extreme emotional distress to people who are relying on that car for their transportation. The dealership comes and repossesses the car, that's an issue. How are you going to get to work? How are you going to pay your bills? So all those factors relate to actual damages in scenarios like this under the FDCPA. Other instances other than credit companies or car dealerships, not likely, because the whole purpose of the FDCPA is debt collection. So a lot of these calls are being a result of debt collection calls. What happens a lot of time actually is someone's calling you about a debt that's not yours. That is also an FDCPA violation, because if you're telling them it's not my debt and they continue to call you, that's a problem. That could also lead into credit reporting issues if they're reporting it on your credit. But if they're just calling you and telling you this is a debt that you owe and you know it's not a debt that you owe, you can fight that. There's no reason for you not to be able to fight that. They'll file a lawsuit sometimes against you saying you owe this debt. And how are you going to defend in that lawsuit? The only way to really defend in that lawsuit is to say it's not my debt and to file a countersuit for FDCPA violations, because it's on them to prove that this is your debt. Fair Credit Reporting Act. So it's essentially a law that protects against issues regarding your credit reporting. Different types of categories. It could be issues such as impermissible credit pull. A creditor or any agency or any person pulled your credit without authorization. That's a violation of the FCRA. It could be an identity theft issue where the credit reporting agency has you confused, or someone stole your identity and essentially racked up all this debt that's not yours, and you are now have to file a police report and dispute all this debt. That could be, if the credit reporting agency doesn't do anything about your dispute, could be an FCRA violation. It could be what's called a mixed file case, where your name is so similar to someone else's name that they mixed your information with someone else's information, and as a result, you have now information on your credit report that's not yours, that's someone else's, and you're trying to dispute it and they're not taking it off, and it's affecting your credit. That could be an FCRA violation. Sometimes the information could just be wrong. You could be current on the loan and it says that you're delinquent. It could be that you're delinquent by 30 days, but it says you're delinquent by 6 months. Because these things affect your credit score, they are FCRA violations, And you could have a case against both the credit reporting, all the credit reporting agencies, and or the creditor that is reporting. So let's say Chase Bank is reporting that you owe them $600 and you've never had a Chase Bank card in your life. Well, you dispute it with Chase Bank and you dispute it with the credit agencies. Nobody removes it from your credit report. You've got a case against all three credit agencies and Chase Bank because you know it's not yours, and you have to battle that out in court. I recommend disputing not in person, but in writing, not online. The online disputes get convoluted and it's hard to track, and you really won't know. It'll be hard for you to send me the documents of your dispute unless you screenshotted everything and printed PDF everything, which is just rarely something that happens. So I recommend you can pull your credit online using annualcreditreport.com. Allows you to pull your credit online for free once a year from all three credit bureaus, Equifax, Experian, and TransUnion. If you need to dispute with any one of those credit bureaus, it has instructions on annualcreditreport.com on how to do that, but it has instructions of where to mail your written dispute. I would write a letter, put it in the mail, send it out, and wait for a written response back. And always keep copies of anything that you send out when it comes to disputes in regards to your credit. Same thing with a creditor. If you're going to dispute something directly with the creditor, then you have to send it in writing, send out the dispute, use tracking like certified mail or delivery confirmation, and have any response sent back to you. Make sure you have your dispute, the responses, and everything lined up so that when you do talk to a lawyer, that's what they're going to want to see. They're going to want to see what is the issue, did you dispute it, and what was the result of your dispute. I would want the client to bring me the issue, which usually depends on how they heard of the issue. I would want the credit reports. I would want to know what's wrong on the credit reports, and what, depending on what it is that is wrong on the credit reports, it's not their debt, or the amount's incorrect, or it's not them at all, then we can do the dispute letter for them and see what the result is. So if you think that you have an issue regarding your credit, what I would really like you to do is to call and have a conversation with me and have you tell me what the issue is. I will then pull your credit with your authorization. I will review it with you, and depending on what the issue is, we'll see whether we need other documentation or whether we have enough to send out a dispute letter. The process can be long because it takes a little bit of time to get something corrected. So just because something's wrong on your credit doesn't mean it's not immediate violation of law. How this comes about is you send a dispute letter, and if nothing is done as a result of your dispute letter, there's no investigation, there's no correction, then it's likely becomes a violation of law. So we have to go through the process. We have to send the dispute letter out. We have to see what the results are. Sometimes the credit bureaus will take it off, and sometimes the credit bureaus say they verified it with the creditor and it's accurate. And even though you know it's not accurate, that's the response that we get. Well, depending on what type of investigation they did or lack thereof, it could be a violation of law. So it's a little bit of a process of going back and forth and setting things up so that you can actually see whether or not there is a violation of law. But it takes time. So damages in an FCRA case are it depends. For example, let's say that somebody pulled your credit without permission, and as a result, your credit score was hit by 30 points. Let's say you had a credit score of 650 and all of a sudden it's 620. And in this process, you were actually trying to apply and get a vehicle. And because your credit score went down, the dealership that had previously pre-approved you has now not approved you, and you lost a $30,000 vehicle that you were going to purchase. Well, that's damage to you. So as a result of someone pulling your credit without permission, causing that credit score to go down to the extent that you lost credit opportunity to purchase a new vehicle, that $30,000 becomes part of your damages because you are no longer able to obtain that vehicle that you were previously pre-approved for. That's a really good example of just some of the damages that you can collect when it comes to credit reporting issues. If you have a credit reporting issues, the first thing I want is credit denials. I want to know if you went and try to get a credit card approval or try to purchase a car, try to purchase a house, and someone's denying you, I want to know the reason for that denial. And they usually have to put it in writing and give it to you. And that piece of paper will tell you why you're being denied. It'll tell you, is it because of something on your credit report? Is it because they can't verify something else that has nothing to do with your credit report? The more things that your credit report affects, the more your damages will be. But we would need to, in terms of that, we would need to stack up the documents to really show what your damages are. TCPA is the Telephone Consumer Protection Act, and essentially it prevents either creditors or advertisers from calling your cell phone without your permission and using what's called an auto dialer. Essentially, it's a machine that just dials numbers, and then you usually pick up and you hear a little click and then someone comes on. That's how you kind of know there's an auto dialer involved. And this act prevents companies from using that system to call you without consent. Now, what that usually means is you apply for a credit card and you sign a very, very long piece of paper and you don't read the terms and conditions. And part of the terms and conditions say they can call you. If you are late on payments, they can call you. Well, if they call you right there and then and say, using an auto dialer, and say you owe $500 on this debt, that in and of itself is not a violation of the TCPA. But if on that call you say, please don't call me anymore, this is my cell phone number and I do not want you to call me anymore, and you hang up, and the next time they call you, now it's a violation. And that violation could be where each call after you ask them not to call you could be worth $500 to $1,500. And it's worth $500 if they're just being negligent and they're just calling and not paying attention. And it's $1,500 if it's willful. They know what they're doing. We have to prove that they know what they're doing. And they're doing it on purpose. And essentially it's malicious. And that could be a violation that could cost them $1,500 per call. So if you tell a creditor to please stop calling you and you owe them $500 and they call you 20 more times, well, at a minimum, take those 20 calls times 500, because that's how much they owe you. It's statutory violation. So the $500 that they owe you per that call is statutory. And that's how much you would be entitled to as a result of that. Statutory means by law. So it's not a number that a jury or a judge can make up. It's a number that's written in the law that says that if you violate this law, every phone call that you make will be worth $500 to the person you're making it. So if you call me and I tell you to stop calling me and then you call me again, that's $500. You call me again, that's another $500. And the key is to log those calls and be very accurate, because the one thing to remember is they're recording these calls. And we have to match up the date and the time and the person. So you can't ignore the calls. But if you have a call log that tells me that these calls came in, and your phone bill is going to essentially verify that call log, that those calls came in at those times, the other side can't say those calls never happened, because we have the documentation to back it up. And it's really important because the amount that you would be entitled to is based on the call log. So you have to be very accurate in what you're asking a judge or a jury to give you, because you want to come off as saying, I did this, I did everything I needed to do, I logged every call, I'm not sitting here and I'm not lying to you, and I'm entitled to every penny that they violated the law for. I would say that any issue that you're having, a lot of us tend to, especially in this day and age, shy away from the calls that we don't know. We see an 800 number and we walk far, far away from our phones. If you're actually trying to punish these people and stop them from doing the violations of law, you can't ignore the calls. So what you can do though is once you tell them to stop calling you, if the same number calls back, you don't need to pick up. But just log that number, that they called back on this day and this time. Whether they leave a message or not doesn't matter, just the fact that they called back. But what happens a lot of times is they call from different numbers. So you don't know where they're calling from. You don't know if it's a different creditor or the same creditor calling. So in that sense, you have to take the call again because you have to know whether or not we can trace it to the same creditor. You have to say, please do not call me to each creditor. You can't say it to Chase and not Bank of America and expect Bank of America to stop calling you. Or then Bank of America would be liable under TCPA because they're not. You have to tell each caller, each creditor caller. So Chase can have 500 customer representatives call you. That's fine. But there might be calling from all different numbers, and we want to be able to log all that. You don't need to tell each one to stop calling you. You only need to tell each creditor once to stop calling you. And then the violations start. Bankruptcy is a couple of different things to a couple of different people. Essentially, it's a way to manage your debt, whether it's through eliminating it completely or whether it's through entering into a payment plan to be able to pay it in a more sustainable way. So we practice in Chapter 7 bankruptcy and Chapter 13 bankruptcy. Chapter 7 bankruptcy essentially allows you to eliminate your debt. You can wipe out anything that is credit cards, medical bills, and sometimes even taxes or tax debt that you owe that's over 3 years old that were filed on time. And the Chapter 13 bankruptcy is generally a payment plan bankruptcy. So if you're behind on your mortgage payment or your car payment and you can't catch up and make one lump sum payment, but you need a payment plan, it's what we call a court-imposed payment plan. So we take whatever amount that you're behind on and divide it by either 3 or 5 years as allowed by the bankruptcy laws, and we enter you into a payment plan where you start to make the payments to catch up on your payment, on the amount that you're behind on. People that generally file bankruptcy are people who have just too much debt and who either fell on hard time and can't pay it or are just way too in over their head. So for instance, in a Chapter 7 bankruptcy, there are a lot of people who were hit by the economy in 2008 that are still recovering. And as a result, there's a lot of debt that's been racked up that is either medical bills or credit card, and they have to just get out. They can't sustain a payment plan. They just need it eliminated so they can do a fresh start, so their credit can start to be rebuilt. Because if you've got that kind of debt to the point where you are considering filing bankruptcy, you need to eliminate it, you probably can't qualify to buy a car, you probably can't qualify to buy a house, and you really need a fresh start. People that have gotten sick and spent a lot of time in the hospital, the doctor visits, start to rack up medical bills to the point of $30,000, $40,000, $50,000, $60,000 sometimes, and it's just not sustainable to pay it back. And so the law provides a option for you to be able to wipe it out, kind of start fresh and move forward. It kind of gives you a fresh start. That's the point of a Chapter 7 bankruptcy. There are certain debt that you cannot eliminate in bankruptcy. So for instance, tax debt that's within the last 3 years, or even if the taxes are older than the last 3 years but were filed within the last 3 years, you can't eliminate in bankruptcy. Any criminal fines you can't eliminate in bankruptcy. Anything that has to do with domestic support or child support, you can't eliminate in bankruptcy. Right now, student loans are, it's very difficult to eliminate student loans within a bankruptcy. The law is just not there yet. So it's right now, if you have student loans, it's very unlikely that you'd be able to eliminate them in bankruptcy. So a lot of people who want to file a Chapter 13 or who need to file a Chapter 13 are facing foreclosure or have their car being repossessed. So for instance, if you're behind on your mortgage payments, the lender could have initiated foreclosure and set a foreclosure sale date for your house. You want to file a Chapter 13 to be able to stop the foreclosure and get into a payment plan to catch up on the amount that you're behind on. If your car is either in danger of being repossessed or has been repossessed within the last 60 days, you can file a Chapter 13 bankruptcy, get your car back, and enter into a payment plan to catch up on the amount that you're behind on. If it's more than 60 days, I can't get you your car back. So you're looking to file a Chapter 7 bankruptcy if you're only trying to eliminate your unsecured debt, such as credit card bills or medical bills. There might be a provision where you get to eliminate tax debt that's older than 3 years, but that's really all that a Chapter 7 will do. So the most important documents for me in terms of a bankruptcy filing, whether it's a 7 or 13, is 6 months proof of income from every source of income for the last 6 months and 2 years of tax returns. So those are the most important documents right off the bat. I will hound you for those documents until we get them, because that really is the crux of whether you qualify to file, which chapter you qualify to file, and how do we do the paperwork. Everything else, there are other documents that we'll need, but we will work with you on those. Those are the most important ones. Once you sign a retainer agreement and bring us the documents, then we fill out the bankruptcy petition using the program that we have. We verify every information with you, gather all your assets, all your debts, we pull your credit, we make sure that your income is accurate, your expenses are accurate, and that everything lines up and you qualify for this type of bankruptcy, whether it's a 7 or a 13, and then we file it. Once we file it, there's about 30 to 45 days later, you're going to go to a hearing. It's called the meeting of creditors, or we call it 341 hearing because it's the bankruptcy code section 341. And essentially it's a 5 to 10 minute hearing with a bankruptcy trustee who's appointed by the court to oversee the accuracy of your case. They're going to ask you whether your income's accurate, whether your assets are listed, whether your debts are listed. They're there to verify the information and to make sure that you qualify for this bankruptcy. That actual meeting is 5 to 10 minutes long. You go with an attorney. After that meeting, if you're in a Chapter 7 case, we wait for the court to stamp your bankruptcy and you'll be done with it. There's a credit counseling course you have to take before you file the bankruptcy and one after you file the bankruptcy, regardless of the chapter. In a Chapter 13, we're trying to get a payment plan confirmed by the court. To do that, we have to make sure that the amounts are accurate and that the judge and the trustee look at your income and your expenses and your debts and approve your plan. And once that happens, then you make your monthly payments for either 3 or 5 years, depending on the plan that we are proposing. And once you are done with the 3 or 5 years, then the bankruptcy court discharges your case or closes it. Essentially, your debts are completed, your payments are completed. Bankruptcy creates what's called an automatic stay, which means that any action against you, any lawsuit against you, any foreclosure against you, any potential repossession automatically stops. No creditor, no action can be taken against you when you file a bankruptcy. That's really important because each time you file a bankruptcy within a 1-year period, you lose a little bit of that protection. So for instance, if you file a bankruptcy in January of this year and it gets dismissed, and you now want to file another bankruptcy, whereas your first bankruptcy had an automatic protection for the entire bankruptcy time frame, your second bankruptcy, you're only protected for 30 days. You have to ask the court to extend that 30 days. And if you file your second bankruptcy and the second bankruptcy gets dismissed and you file now a third bankruptcy within a year, there is no longer any protection. There's no automatic protection against any action against you. You have to file a motion and ask a judge to impose the protection. And sometimes, most of the time the judge does, but there are times where the judge doesn't.
depending on the reasons for the prior dismissal. So it's very important to tell us if you filed prior bankruptcies, whether they've been dismissed and the reasons for those. You didn't submit the paperwork that was required and you didn't submit the payments that were required, your bankruptcy will be dismissed.